Welcome everyone to the very final session in our Smarter in September series in 2021. This has gone so quickly and it's been so much fun and so informative. Today's session is Smarter Estate Planning, and our presenters are two of UBT's experts. We have Leslie Gibbens and Doug Koenig. They're both vice presidents in our personal trust and wealth management division. And they're just amazing people. And both of them just are a wealth of knowledge. They're going to talk about what goes into a smart estate plan, why it's important to have one, and how to go about doing that. Their presentation is very comprehensive, so you probably won't have questions by the time it's all done. However, if you think of something, by all means, use that chat feature down at the bottom of your screen. Type your question, and we'll ask it at the end. Thanks so very much, and we're just going to jump right in. Doug and Leslie, would you like to take it away?
Thank you, Kelly. Can you hear us okay?
Thumbs up. I can hear you great. Thank you.
Well, thank you, everyone. It's really great to see so many people on the seminar today. We sure welcome you all. To start off, I'm going to give a little bit of introduction in reference to what Doug and I do here in the Personal Trust Department at Union Bank. We are both personal trust service advisors, and I have been at the bank for over 20 years now. Time goes way faster than I anticipated. My background is in accounting, and the best thing about my job is the opportunity to work with individuals like we have here today. Doug and I will work with clients that we meet with as they are working on their estate plan, maybe looking at putting an estate plan in place for the first time, or maybe updating one that they have in place. And we work with not only those individuals, but their team of advisors. So that might include their estate planning attorney, it might include their CPA, it might include their insurance agent. But we sit down and really serve in a consultative fashion to help review those estate plans. And then the trust department serves in a capacity as personal representative or trustee. But again, I've been here, love what I do, get to work with many individuals, and Doug and I work very, very closely together. And Doug, I'll let you share a little bit about yourself.
Sure. So thank you, and good to be here today and talk to you guys about estate planning a little bit more. Really, Leslie and I do the same thing here at Union Bank, everything she just said. The only difference is she's been here 1 year longer than me. So I'm almost at 20 years at Union Bank and enjoy it. I really love the diversity of my job, just like Leslie was saying. It's working with all of you and helping you establish that estate plan and review it, but also working with all the professionals, all our team members at Union Bank, just the broad diversification of what we do, and being part of your professional team is what I really enjoy about what we do here.
So our goal today is to talk about a smarter estate plan and estate planning. So what we'll do is dive right in here. And when we visit with people and talk about an estate plan, some have already started their estate plan, some haven't done any work at all. And we'll have clients that sit down and ask us, so do I just need a will? Well, a smart estate plan includes much more than just a will. And you'll see here on this screen, those documents that make up a good estate plan. And we're going to talk in detail about each of those, but I want you to think about these as we visit. The first one is a durable power of attorney for financial matters, and this is where you appoint someone to carry out, while you're living, duties of a financial nature that you are not able to. Then there's the healthcare power of attorney, where you appoint someone to make healthcare decisions on your behalf. Then you've got your last will and testament. In addition, you could have an outside trust agreement, a revocable or even an irrevocable trust agreement. These documents make up a good estate plan, a smart estate plan. But you're not done there. Beneficiary designations and titling, which we'll get into and discuss more, are also such an important part of a smart estate plan that you need to be considering as you're putting your estate plan into place, you're updating one, and reviewing. Anything I left off there, Doug?
Well, I might just say that, just as Leslie said, this is the complete estate plan. So if you have one of these documents or two of these documents, Leslie and I will tell you it's not complete until you get all of these in place. And we're going to delve into them a little bit further so that we can explain why they're so important as we go forward.
Yeah. Let's go to the second slide here.
Okay. We just wanted to put this up just to kind of give you an idea of maybe how you compare to other people in the United States. So less than half of all adults in the United States have an estate plan in place. And this is according to a Gallup poll in May of 2021 this year. So we look at this and we think, okay, we got our work cut out because we're going to tell you everybody needs an estate plan. So then we kind of break it down age-wise a little bit just to get a little bit better understanding of that 46% of U.S. adults. So thankfully, those who have retired or nearing retirement have a little better percentage, and those that are younger don't have as good as percentage. But again, we're going to say that everybody needs an estate plan, and even those younger people who may not have a lot of wealth at this point or assets, there's other reasons that they really need that estate plan in place. So yes.
And Doug, I just thought of it. I thought of something to share with the group here today. We've dealt with a lot of parents recently who have had children go off to college. And what so many of our attorneys that we work with are advising that those college students get power of attorney documents in place, both for financial matters as well as healthcare, so that their parents have the ability to assist them. If the worst case scenario would arise, those need to be in place and they can step in.
I couldn't agree with you more. So just to accentuate that previous slide a little bit more, Leslie and I are always talking about creating urgency for people to get their estate plan done. Really, when is it too late to get your estate plan done? When it's too late. And so if at some point somebody's not able to make their own decisions and sign documents and things, it becomes too late. Leslie and I have been involved in some unfortunate situations where people in crisis are trying to get their estate plan done. And that is the wrong time to do estate planning, but sometimes it's necessary. And there's been a few times that we've been called to the hospital where people are in their last couple final days or hospice or something. And it's tough to watch that happen because really, I wish they were focusing more on their family and other things at that point, and they would have had their estate plan done. So we're always talking about that urgency to get that done in a time in which you can make good decisions and you're not under a crisis situation.
I really agree with that. And you want to be in a state of clear mind when you make those decisions, and the hospital usually isn't that place. So Doug and I are always trying to create that urgency.
Yeah, and you see the peace of mind people have when they actually get their estate plan done, or they reviewed it and made a few updates or something like that. I also tell people that it really forces people to get organized with their thoughts and their assets and things like that. So there's some side benefits to getting that done as well.
And that'll lead us right into the next slide, Doug. Thank you.
Yeah.
So when we're visiting with people, they can feel a bit overwhelmed when they think about, how do I put that smart estate plan together? So we want to just take it step by step. And I think the first step is, as Doug indicated, get organized and gather your financial information. I always like to tell couples, sit down and really look at what your assets are. Take a financial picture. Maybe put that financial statement together. And we're getting close to tax time, unbelievably so, but that's the time that many people will sit down and they'll look at all of their assets. So take account of those. Look at your checking and savings accounts. Take a look at your personal tangible property. What would you want to have happen to that? Do you have valuables? Maybe it's jewelry. Maybe it is, guns that have been in the family for a while. Maybe it's the buffet that grandpa made. Those are all those tangible property items that may have some significance to you and your family. Take account of real estate assets. Are there farm property that you want to pass down to family? How about rental property? Do you have a number of properties that you rent? Make note of those. How about your retirement accounts? 401ks, 403bs, IRAs, both Roth and traditional. Make note of those. Write those down. How about taxable investment accounts? Do you have accounts that you manage? Do you work with outside investment brokers? Make note of those. How about business entities? Do you have an LLC? Maybe a partnership? Gather those documents and make note of those as well. Life insurance policies. Maybe you've got term life insurance. Maybe you've got whole life insurance. Gather any annuity contracts that you have so that you really have a good accounting of all of what your assets consist of. And then finally, make note of those debts. You've got your mortgage, maybe you've got car loans, maybe you've got business loans, and these become important when you're looking at your estate plan too. Now you've got all of this information together in one place, you jotted it down, you know what you've got, you've had a good conversation with your significant other, or you've thought through your own goals. I want you to take all of that when you go in and you visit with your estate planning attorney, and I want you to share those. I'm always concerned when I visit with somebody who has gotten their estate plan done and they say, well, I didn't tell my estate planning attorney about that partnership, or I forgot to say what my intent was with the farm property. Jot it down so that you've got it in front of you so that you can talk about it and share those assets with the estate planning attorney. And make sure then you share what your dispositive intent is for those assets. Where do you want those to go? How do you want those to be split? Are there charities that are important to you? Do you want everything to go equally to your children? Do you not want everything to go equally to your children for good reason? And here's that good reason. So the first step, get organized, take note of what those assets are, bring documentation, have documentation for those assets where appropriate, understand what your debt is, and share those items with your estate planning attorney.
So Leslie, when you go through this, I remember a couple of years ago, we were giving some presentations and you published a nice piece called Create a Roadmap for Your Estate Plan. So really that's what you're doing here, is just creating a roadmap for other people to follow, you to follow, the professionals to follow. And this might be the right time for me just to direct people to our blog site on the Union Bank website. So at ubt.com, you can go to the Learning Center dropdown, and there you can go into searching for different topics, and we'll have a lot more articles and publications on estate planning that you guys are welcome to go visit that and read more in depth on a few of these topics today.
I think our kids would be proud of us if we could say we were bloggers, Doug.
Sure, yeah.
All right, so now you've gathered all of this information and you've made the smart move to go into your estate planning attorney and get that estate plan in place, or update one that you have in place. And the first document that I'd like to visit about is that last will and testament. And you know, that will have a number of provisions. One of those will include what you want to do with your tangible property. And many times, you know, I leave everything to my spouse. And then if my spouse is not here, then I leave everything to my children. But you will have the opportunity to create what we call a laundry list, where you will indicate what you want to have happen to specific tangible property. Again, I'm going to talk about that ring that you have, maybe it's grandpa's watch. That laundry list is a document that's outside of your will that is preferenced in your will, where you say, I want my niece Susie to have my wedding ring. You sign and you date that. You must sign and you must date it. It can be updated, but we never like to see somebody cross it out. I want you to start over when you create that laundry list if you want to change things. But your last will and testament will have a provision for that tangible property distribution. If you have real property that you want, for instance, somebody to have the first right of refusal to purchase that property after you're gone, you'll also have a provision within your last will that can address that. The will also allow your personal representative, will direct your personal representative to pay your final expenses, maybe final medical expenses, pay your final taxes that are due. And then you'll have the residual of your estate where you indicate how you want your assets to be distributed to charities, to individuals. Maybe you'll have a pour over will, and that residual will pour over into your revocable trust. For those that may have minor children, your last will and testament will indicate who you appoint as the guardian for those minor children. Such an important part of your last will and testament. If you don't have a will in place, and we saw that there's a great percentage of those that do not, I want to share with you that the state of Nebraska has a will for you. And you die what we call intestate. And in that situation, the court will decide where your assets go. And depending on the complexity of your family situation, if you have parents alive, if you have a spouse that is still living, or you have children, that will determine who receives your assets. But no, it might not be who you want to receive your assets. So getting this will in place is the smart thing to do. And again, we try and create that urgency so that you get this in place. Finally, I'm going to touch on, within your will, you're going to appoint a personal representative, and Doug will expand on that. But the personal representative in your will is really responsible for collecting your assets, making sure your final expenses are paid, and then distributing those assets. They're also responsible for making sure final taxes are filed and paid. And it is a big responsibility, and it can be somewhat burdensome and very time consuming. So that's the last will and testament. Doug, did I forget anything?
No, I think that you're right on point.
All right. Well, I'm going to turn it over to you then.
Sure. So as Leslie showed on one of her slides previously, a complete estate plan can include these different documents that we're talking about here. Now, a trust might be part of your estate plan, but it might not be part of your estate plan as well. That's just going to depend upon your situation, your assets, how you want things distributed, that type of thing. But we want to talk about it here a little bit. So the first thing I'll just talk about is revocable and irrevocable trust. So what's the difference? Well, a revocable trust is just like it says, it's something that you can amend, you can change, you can revoke, you can do whatever you need to do with that. An irrevocable trust is something that a person can set up. Once they set it up, they can't change anything about the trust. They can't amend it, they can't revoke it, it's there. And there's different reasons for these different types of trusts. So there is a type of trust that, and that's that top one up there, that testamentary trust. Well, it's not actually a separate document. It's actually something that gets set up in your will, like Leslie was talking about the will in the previous slide. So a will only takes effect at your death. So a testamentary trust is inside the will. It's got language in there that directs a trustee to handle assets in a certain way and benefit those who you have designated to benefit from them. So the testamentary trust never comes to life, so to speak, until you pass away or the second of you pass away. And so there's not a need to have a separate revocable trust. And again, your situation and assets may help decide which is the best type for you and whether you even need one. So a revocable trust is something that you create and it exists during your lifetime. It's a contractual arrangement between you and the trustee. A lot of times during your lifetime, you're the grantor or the author of the revocable trust, and you're also the trustee of the trust. And you create that. Some of the benefits of the revocable trust is it will withstand all stages of your life. So, during your lifetime, and you're able to make your own decisions, you can put your assets in the trust or title them in the trust so that the trust owns them. But since you're the trustee, life can continue as normal. You can manage those assets. But you also have named a successor trustee of the trust so that if you become incapacitated and can't make your own decisions, you've named somebody to take over that role of trustee to manage your assets for you. And in normal situations, that trust remains for your benefit during your lifetime. And that's the trustee's job to handle that trust that way. And a revocable trust also withstands your death. So the trust will say, well, at my death, then here's what I want to have happen with my assets. Here's how I want them handled. Here's who I want them to go to, which could include individuals, charities, and maybe sometimes there's a reason that you want those assets managed for a period of time after you're gone. And there's all different types of reasons for that. There's sometimes just, maybe there's a child who just does not handle their finances well. So you want to make sure that they're well taken care of for the rest of their life, and you want another trustee to manage their trust and their assets for their benefit during their lifetime. Sometimes there may be a beneficiary with special needs. They're on public assistance programs, and if you left money to that person directly, that may jeopardize their public assistance programs they may be on. So you want to create that special needs trust inside the trust so that it can supplement their life, but not take them off of their public assistance benefits that they may be getting. And the other thing with a trust is you get that put into place, you're thinking about all the what ifs. Well, what if my child predeceases me? Then where do those assets go? Do they go on down to that deceased child's children? Or you can You can say anything you want to in that revocable trust, and this is a way to do it. I'm just going to briefly mention the irrevocable trust, and there's lots of different reasons to set these up. Sometimes the primary reason to set this up is to get assets out of your estate. We're going to talk about death taxes in a few slides from now, which will help clarify this a little bit. But sometimes people want to get assets out of their estate so that it reduces taxes. Sometimes they want to get a charitable deduction, so there's trust that can help with that. Sometimes it's a matter of an effective way of transferring wealth to the next generation. So, and I just mentioned those. And again, there's lots of different trusts out there that do different things, and it's just really dependent upon your particular situation, your assets, and what you're looking to, what your goals are, and what your goals are for your family, you know, once you're gone, as well as during lifetime.
And you know, Doug, I'm just going to add a couple thoughts come to mind here. I'll have clients that will ask me, well, if I set up the trust, I lose control. And they really don't in that revocable trust situation. You know, they're the trustees. They can, for instance, put their home in the trust. Doesn't create problems when they go to sell that house. They're still in complete control. And I also thought of a couple what ifs that I ran into recently. Unfortunately, we have had a couple charities that individuals have left funds to, and those charities have gone out of business. And they were able to say in their trust that if this charity is no longer, here's what I want to have happen with those funds. So that revocable trust is such a really great tool when you're doing your estate plan.
And Leslie, I failed to mention, and it's right there on a bullet point, creating a trust, a revocable trust, irrevocable trust can avoid probate as well. So another thing about creating trust is it doesn't become public information. So, you know, a will has to be probated. So it's going to go through the courts, and it can be public information if people really want to look it up. But assets that belong to your trust when you pass away, avoid that court process and avoid the public eye, and can avoid some of that time and expense involved in that. So that's another benefit of a trust. So.
Thanks, Doug.
So I'm going to continue
very good.
on.
Okay. Very good.
So just talking about a few of those other documents that Leslie had on our initial slide about a complete estate plan. So power of attorney documents, very important. So there is a financial power of attorney document. So if at some point you're not able to, either because you're not physically in a location or don't have the mental capacity to make your own financial decisions anymore, who's going to do that for you? So a financial durable power of attorney makes sure that your financial life doesn't get disrupted. So, and you can limit powers, you can give broad general powers to do things, and there can be different reasons for doing that. And we'll talk about maybe, you know, those people you think of to name in that position. Another power of attorney is the medical power of attorney. So if you're not able to make your own healthcare decisions, then who is going to make those healthcare decisions for you? It'll have the HIPAA language in there so that those people can make sure that they can communicate with doctors and healthcare providers to help make those decisions. It isn't necessarily an end-of-life decision that is made, although these people can have the power to contribute to those types of decisions. But really, end-of-life matters comes with a living will or advanced health directives. This can be part of the healthcare power of attorney. Sometimes it's a separate document as well, but it really deals with end of life, and it's your directions to the doctors on how you want that to happen. So those are the other documents that kind of makes that complete plan that you were talking about, Leslie.
And Doug, I'm just going to reiterate, again, those documents are really only valid while somebody is living. I have many individuals that I'll visit with, and they'll say, well, I'm their power of attorney after a person has passed. So once somebody passes, those power of attorney documents are no longer valid.
That is correct. So yes, once you would pass away, then it's the will or the trust that would take over in those situations. So
Okay. Well, this slide is mine. So now you've got those documents in place. You know, you've created your will, you've done your power of attorney documents, maybe you've got your trust documents in place. But you need to stop and look at what your assets are at that point and look at how they're titled. Many of our clients will get their estate plan done, but the work is not done. Then they need to look at how their assets are titled so that they coordinate with their estate plan. And you can hold your assets in these three ways. So maybe you'll hold an asset jointly with rights of survivorship, say with your spouse. And in that situation, my husband and I own my house jointly. If I were to pass away, my husband owns that asset after I'm gone. You can own assets as tenants in common. And in that situation, my husband and I own our home, each having an undivided interest in that home. And if I were to pass away, my husband still owns his share of the home, but my share will pass according to my either estate plan or beneficiary designations. Or you can own an asset individually. So I own my home outright. But we've got to look at and talk about beneficiary designations. If you do not have a beneficiary designation and you own an asset individually, then that asset will be subject to probate and will go through the court system. The courts will look to your will and see how you have left your assets. So it will be distributed according to your will if you have a will in place. But putting those beneficiary designations on your assets is really part of a smart estate plan. When you look at your beneficiary designations, you can consider a transfer on death designation. So let's say I have assets and an investment account and I own it individually and it's a transfer on death account to my daughter after I pass. When I go, it's going to go directly to my daughter. It's not going to pass through my will. It's not going to pass through my trust. It's going to go to my daughter. Same thing with a payable on death designation. I have a POD on my checking account, again to my daughter. However, if that TOD or that POD is to my revocable trust, those assets after I'm gone will pass to my trust and be distributed according to the dispositive provisions within that trust document that deals with all of those what ifs that Doug referenced. You will have the opportunity to put a primary beneficiary and a contingent beneficiary on your assets. So let's talk about that. Let's say I have got my IRA titled in my name. My primary beneficiary is my husband, and my contingent beneficiaries, if he predeceased me, is my children. So make sure, this is such an important part of the estate planning process. Look at all of your assets. When you started this whole process out, you took an accounting and you got organized and you wrote down all of those assets. Now go back to that and see how those are titled and how will they pass after you're gone. Go through asset by asset. Look at titling and beneficiary designations. Are they going to pass according to your beneficiary designations, or are they going to be directed to your trust and be distributed according to your trust document?
So just a comment, Leslie, on just understanding some of those is, how you can own your assets. So, a really common thing in Nebraska is farmland.
Yes.
And so I meet with clients sometimes and they say, well, I do own some farmland with my brothers and sisters when mom and dad passed away, and one brother's farming the land or something like that. And I asked them, so do you own that jointly with your brothers and sisters, or do you own that as tenants in common? And, it raises a question sometimes for the first time. So it's just to get you guys thinking about that a little bit too, because I'm sure there's somebody out there with that situation, and, the difference in ownership and how that affects your estate plan.
Doug, it's so important to go through each of those assets individually. So you talk about farmland. I'm going to talk a little bit about those business entities, because you've got, articles of incorporation or specific documents related to those entities that need to be reviewed at this time as well and become part of that ownership and how those assets are going to pass. So good things to be thinking about.
Yeah. And the only other thing I'm going to say about this is Leslie and I talked about a complete estate plan. This actually completes the estate plans, because we've sat down and talked with people before and they've gone and signed all their documents and they're like, yeah, I got my estate plan done. And then we'll have a conversation about beneficiaries and things and find out it doesn't even coordinate with their estate plan. And in fact, they've created a new estate plan by some of the designations they've made. So this is a really important step after you sign the documents to get everything the way it should be.
I'm going to add, it really needs to be reviewed annually. And I'll give you an example there. So maybe during the year, you set up a mutual fund and you put one child on. And this is something we see with new parents. So they begin to start to save more. They set up a mutual fund or an investment and maybe put one child. But then in 5 years, they have another child and that child is never added. Or their updated estate planning, their trust was not added. So it's just really good to be reviewing this on an annual basis.
Very good. All right, so the next really important topic is just talking about, in talking about these different documents. So Leslie mentioned you need a personal representative for your will. You need what's called an attorney in fact for your durable power of attorney for financial. You need a trustee for a trust. So who is going to do that for you? And as you think about, that, you may think about a child, maybe the oldest child of the family or something like that. But you really got to ask yourself some questions when you think about this. So whoever you name in these roles, they are a fiduciary. They take liability for acting. So any mistakes they make, if anybody's unhappy with them, they're responsible for all the decisions that are being made and serving in these capacities. So we always talk to people about, well, let's make sure that, for one, you trust that person. So don't be putting somebody in that position that you don't trust to handle these things for you. The other things to kind of ask about is, well, does this person have the skills, the financial skills? Do they have the flexibility to do all of this work? Are they available? The other thing that Leslie and I talk to people about is, whoever you name in these positions, you're putting one person in charge of the inheritance of all the others. So let's take a family and you put one child in charge of everything that's eventually going to get distributed to their brothers and sisters. Well, if there's any friction or, problems or relationships there, grief and greed only expands that friction or makes greater friction. So think about those things. So and the other thing is, the people you name in these positions too, they need to be impartial and they need to have the appearance of being impartial. So their job and their duty is to act in the best interest of all the beneficiaries. So they need to do that.
And Doug, I'm just going to add, I think when I visit with our clients, one of the biggest legacies that they want to leave, and frankly, one of the greatest legacies that I want to leave is a family that gets along well. I want my kids to remain in a very positive relationship with each other after I'm gone. And as you've shared, it's not always easy to do when you appoint one child over another.
Yeah.
And an independent corporate fiduciary in that situation really might be the best situation.
So, and every family is different. So we've seen it work out just fine with an individual. But the other option, like Leslie said, is to name a corporate fiduciary in these roles. So that's somebody like Union Bank. We serve as personal representative or trustee or durable power of attorney for people. So we have the skills, we have the expertise, we have the time, we have the flexibility, we have a whole staff. It's what we do every day when we come to work. We have all the people with experience in doing this. We have some tough situations. We're able to talk about it with the team and come up with the best solution because everything isn't always cut and dry. We are going to be impartial. We're going to look out for everybody's best interests. So it's just things to think about as you name these people in these positions. So you need somebody to represent you to get these documents in place. So Leslie and I always say that there's lots of ways to get that estate plan done, but we really feel like the best way is to go see an estate planning attorney to represent you in drafting your instructions and how you want things handled. So they're going to do it in a way that they're going to listen to you. They're going to ask the questions. They're going to make sure that they're going to do the best planning for you and your family.
And Doug, I'm going to add on that. There are a lot of proposed changes before Congress right now, and those estate planning attorneys are going to be up to speed on those.
Yeah.
And be able to incorporate those significant potential changes into an estate plan.
Correct. Yeah. So one thing we always get asked about is taxes with estate planning. So we're going to talk about real quick death taxes. So, there's all kinds of other taxes out there, but what's the effect on my estate when I die? So the way things exist right now, every single person has the ability to give away $11.7 million when they die. So a married couple, if you think about that, if each one has the ability to give away 11.7 together, you have the ability to give away 23.4 million. So very few people are going to pay federal estate tax, and maybe there's somebody on this call that will, but percentages or chances aren't likely for that. So at this time, you don't have to worry about the federal estate tax so much unless you have a different situation. But things change all the time with laws, so you need to be aware of that. In fact, there's a lot of proposals on the table right now, and we're going to see how all those work out. But the other thing is, and Leslie did a little research before we came in, because we always talk about Nebraska Inheritance Tax. And then we say, there's just a handful of states that have inheritance tax, and Nebraska happens to be one of 6 states in the United States that has inheritance tax. So that is another death tax, and that tax goes to the county of which you are a resident of. There's a class 1 beneficiary, a class 2 beneficiary, a class 3 beneficiary, depending who you are leaving your money to, and they pay different tax rates. So the other thing that a lot of people do take advantage of, no matter what their wealth situation is just the annual gift tax exclusion. So everybody has the ability to give away $15,000 per year to as many individuals as you want, and you don't have to file a gift tax return. So that's another thing that will help sometimes reduce your estates, but it's also a nice thing to take advantage of, if you can benefit members of your family and things. So
All right. I think that concludes the information that we wanted to provide today in reference to a smarter estate plan. We always have to have our disclaimer. Doug and I are not attorneys, so we're not providing any legal or tax advice, but we hope that the information that we provided today was informative to you. Finally, we have got our contact information. Doug and I are here as a resource to each of you, and we surely invite you to give us a call, shoot us an email, let us know how we can help at any time. Again, the best thing about our jobs is getting to know you and getting to know how we can help you. With that, Kelly, if there are any questions that you have got, we're happy to answer those.
I have two for you, if you're ready. The first one is, how do I provide for my pets after I'm gone?
What a great question. I've got a little bit of a story on that. Recently worked with a wonderful individual who had passed away. She had 3 pets, and they were included. There was a provision within her trust document that addressed the care for those pets, both the physical care as well as the financial care. So you can incorporate the care for your pets right in your trust document. But again, it's one of those things that you want to be sure, working with a good estate planning attorney, that you share your concern for those pets, that you identify who you would want to have take care of them, and then the financial benefit for whomever is going to do that within that document as well.
That's great. Thank you. My sister came back recently from visiting with her estate planning attorney and said to me, I just want to make sure that it's okay that you take whichever pet I have. And I want you to know that the 2 of you will be able to have a nice life. So I think.
well, Kelly, I mean, that question really does bring up a good point. You know, Doug and I work a lot with finances, but as Doug alluded to, families are very unique, and there are many situations that maybe go outside of that financial circle that we are working with, and pets are one of them.
Yeah, that actually, if we're administering a trust or something, we're so happy when there's instructions in there about how to take care of the pet. So great consideration, and should be considered as you're doing it. Sometimes it doesn't necessarily go in the document. You just have an arrangement with a neighbor across the street or something like that. But you can do about anything you want with that. Yep.
Great, thanks. Well, the next one is also, it's not really along those same lines, but what do I do with my safe deposit box?
So I'm curious if are they talking about titling, or are they talking about assets that they might have within their safe deposit box, or documents that they might have within their safe deposit box?
They're not giving me any more information. So if you ask this question, feel free to type in more to me. Otherwise, let's assume that it's the contents of the safe deposit box.
So ownership is a big thing. Who owns that safe deposit box? So if it's the individual that, let's say, has passed away, then those contents are now part of their estate, and they need to be dealt with according to what the document says. So you find different things in that safe deposit box. So if it's a bunch of cash, well, then that becomes part of the estate proceeds. If it's, we find gold bars or gold coins, we have to, jewelry, from our standpoint, if they haven't named who gets the jewelry on the laundry list or something, it's our job, if we're the ones who are administering it, we have to find the market that will get the highest value out of those assets in that safe deposit box, so that the beneficiaries can benefit from that. So,
and one thing that I think is so important, and we run into this a lot, whomever you've named as your personal representative, they need to be able to find the key to that safe deposit box after you're gone. For those clients that name us as personal representative, one of the benefits of naming us is we offer to hold original documents within our vault when we're named. And we have some clients that will give us a copy of that safe deposit box to hold in our vault, because getting into that safe deposit box is important after somebody passes away.
Yeah, because on that point, and this is a very real thing, it's like if the original will is in the safe deposit box, nobody has any authority to get in the safe deposit box. So sometimes you have to go to court and get approval from the court to drill the safe deposit box, to get in the safe deposit box, to get the will, to probate the will. So where that original document is and who has access to it, and that's something we talk about all the time, but we didn't talk about today. But location of original documents are very important, and how do the people that are put in charge get to those documents. So.
And Kelly, I can see a question in the chat from John that says, what would the Nebraska Inheritance Tax be on an estate of 1 million, all cash within the portfolio? And it really depends on who you have left your assets to. So Doug kind of talked about the inheritance tax is a beneficiary tax, and Nebraska has 3 beneficiaries. A class 1 beneficiary, you have an exemption amount of 40,000 you can pass on to that class 1 beneficiary. Anything over 40,000 is taxed at 1%. A class 2 beneficiary is a little more extended relatives, and you've got the ability to pass on, I think, 15,000. Yeah, 15,000, and anything above that is taxed at 13%. And a class 3 beneficiary is, you can pass on 10,000. Anything above the 10,000 is taxed at 18%.
And those classifications, like class 1 that Leslie was talking about, that's usually your lineal descendants, so straight down.
Yeah.
Class 2 is you go back up to brothers and sisters and down to nieces and nephews and cousins. Class 3 is non-blood relationship.
Your neighbor.
Perfect. Okay, thank you. And Lori was just asking for clarification on that gift tax. Was that 15,000 a year or for multiple years? And she just wanted you to clarify, please.
And go ahead.
So that's per year?
Per year, yeah.
So I can gift $15,000 to each one of my children every year. Well, that's adjusted.
Yeah, and Leslie can give 15,000 to me, 15,000 to Kelly, and 15,000 to all of you per year, and no gift taxes.
That would bring me great joy.
Well, as it would to us. So we look forward to that. Thank you. We're asking for a recommendation of a good book that covers the material presented today, maybe with templates to use.
You know, there are some good books that are on my bookshelf back in my office. I would ask Vicki to shoot us an email on that, and we can do a little bit of research on those that we've got.
Perfect. Okay. Well, I don't see any other questions. I would like to put in a plug as well for the ubt.com website and the Learning Center and Doug and Leslie's blogs. All of you on today have actually read or seen at least some of those, because Doug and Leslie might not know this, but I include one in almost every monthly Journey e-news and often in the quarterly print newsletter. So they're good stuff. They're timely and relevant, and I would absolutely go out and look around a bit. Doug and Leslie, did you have anything else for us today?
I don't. We just thank you for the opportunity to visit and share, and sure invite anybody to reach out to us if we can help in any way.
Perfect. Well, thank you so much today for this fabulous content and for the gift of your time. Thanks also to Caitlin Moore and Nikki Davison, because we couldn't do this without them. And thanks to all of you. We certainly couldn't do it without all of you. Thanks for tuning in this Tuesday afternoon. We have a request to put your emails up there again, if you can get to your PowerPoint.
Sure.
Otherwise, I can get it to anyone who is interested. Mark your calendars for October 26th. Here you go. Doug is sharing. Leslie.gibbons@ubt.com, Doug.Koenig@ubt.com. I know you can spell both of those last names. Leslie's is Gibbens, and Doug's is Koenig. So perfect. Thank you. Mark your calendars for October 26th, which is a Tuesday at 2, where we'll be ensuring that you are Medicare ready. Our presentation is, Are You Medicare Ready? And we'll have Alicia Jones from the SHIP office and Craig Pitleski from Union Investment Management Group. Plan on tuning in also in November, every Tuesday at 2, and we're going to try very hard to make your holidays happier.
Kelly,
So thanks.
I'm just going to add, Alicia is wonderful. I'm going to put a plug in there for her. Craig is wonderful as well. Alicia does such a good job explaining.
Great. Well, thank you for that. So we hope to see everyone again. Thanks so much. Have a great rest of your Tuesday. Bye-bye.